We'll finish قاعدة الاستحقاق. We'll move on to فعل بعض المأمور إن شق فعل كله, which is the next line number 38, which is where it's actually an offshoot of المشقة تجلب التيسير. It's an offshoot of المشقة تجلب التيسير. So it comes under a generic principle, but it's an exception to it. So we'll look at that inshallah ta'ala now. تفضل أخي.
قال رحمه الله ويفعل البعض من المأمور إن شق فعل سائر المأمور.
So the author, he says ويفعل البعض من المأمور, that if part of what you are commanded to do, if you are capable of doing it, you should do it. يفعل البعض, you do a part of it. إن شق فعل سائر المأمور, that if the entirety of the act is too difficult for you to do. What does this mean? It means that what is possible for you to do is not invalidated by what is not possible. So we'll see inshallah ta'ala some practical examples of it. But just because you can't stand for prayer doesn't mean you leave off prayer in its entirety. Okay? That's what this principle means. So it's commonly actually referred to as al-maysur لا يسقط بالمعسور. الميسور يعني ما كان ميسرا لا يسقط بالمعسور. لا يسقط بالمعسور. And so what does this principle say? It says and expresses two things. The first is that if a person is not fully capable of fulfilling a command, then he needs to do the portion that is possible for him to do. What you're capable of, you still need to upkeep. So this leads us to the next point, which is the inability of you doing the entirety command is not an excuse for you to leave it off. That's all this statement says. Al-maysur la yasqutu bil-ma'sur. So yes, as we covered yesterday, that at-taysir, the ease that we see in the Sharia, is the cornerstone and the bedrock of al-Islam. Right? يريد الله بكم اليسر ولا يريد بكم العسر. But this is not an excuse to just, leave off actions entirely. تسقط عبادات بأكملها. That's not allowed. And we see examples of that throughout the Sharia. Some of the evidences quite quickly of this قاعدة فاتقوا الله ما استطعتم. Allah Azza wa Jal connected His commandment of taqwa to what we are capable of. What you're capable of, fear Allah tabarak ta'ala. Be conscious in doing. Be conscious in doing. So fear Allah tabarak wa ta'ala as much as you are able. Allah tabarak wa ta'ala says, لا يكلف الله نفسا إلا وسعها. He doesn't burden you beyond what you are capable of. And so what you are incapable of drops. But what remains within your capability, what is still within your wus'a, does not drop. It remains and you have to fulfill them. And that is how we understand this ayah. So we have to do what is within our means. The Prophet ﷺ said in the hadith that was narrated by Bukhari, hopefully every single one of us will know this hadith, we see it in أربعون النووية. إذا أمرتكم بشيء أو إذا أمرتكم بأمر فأتوا منه ما استطعتم. That if I command you with something, then do of that command as much as you are capable of. And so what do you see in this hadith again? What drops is what you are incapable of. But what you are capable of, you still need to do. We're going to look at some of the applications, inshallah ta'ala, now. Obviously, the most obvious ones, we just start with just to make some things clear, which is that the individual who can perform salah with some limitations, right? Al-ajiz an ba'd al-arkan aw al-wajibat. The person who is incapable of some things, but he's able to do other things. How does he pray? He needs to pray in whatever manner he is capable in praying in. And the Prophet ﷺ said in the hadith, صَلِّ قَائِمًا فَإِن لَمْ تَسْتَطِعْ فَقَاعِدًا فَإِن لَمْ تَسْتَطِعْ فَعَلَى جَنْبٍ. If you can't pray standing, then pray sitting. If you can't pray sitting, then pray on your side while lying down. Nawawi rahimahullah ta'ala says, إِذَا عَجَزَ عَنِ الْكُلِّ أَتَى بِالْمُسْتَطَعِ. That if he's incapable of doing the entirety of the act of worship in the way that Allah Azza wa Jalla commanded him with, he needs to do what he's capable of. He needs to perform it in a manner that he can do it. And then he says, وَهَذَا أَصْلٌ فِي جَمِيعِ الْعِبَادَاتِ. That is the foundation and the principle for all acts of worship. And so this applies to everything. The obvious thing here is what? Is if this ibadah is obviously from the ibadat that tajazza, that you can break apart. There are acts of worship that you can't break apart. So right now, for example, I'll say to you, for example, somebody was incapable of fasting a day of Ramadan.
Cannot fast half day.
You can't half fast a day. So what do? You just avoid fasting that day and then you redo it in other days. You make it up in other days. So just because you can't fast that day of Ramadan is not an excuse to leave off the entirety of Ramadan. Does that make sense? So jot that down as well, because that works as a good example. And you see that in some of the works of the fuqaha. If somebody has got a marad muzmin, right? A sickness that's, that prevents him from fasting in its entirety. It sticks with him throughout his life. Some sort of health issue, because of that he cannot avoid consuming things during the daylight hours. Do we say to him, khalas, you don't need to fast, you don't need to do anything? Salaam alaikum. What do we say to him? Fidya. وَعَلَى الَّذِينَ يُطِيقُونَهُ فِدْيَةٌ طَعَامُ مِسْكِينٍ. And obviously this ayah nusikhat. The taqa, what you were capable of, was replaced with the fasting of Ramadan the following year. And so what remained was that the people who were incapable of fasting, they need to come with fidya. Ibn Qudama rahimahullah says, إِذَا عَجَزَ عَنِ الصَّوْمِ وَجَبَتِ الْفِدْيَةِ لِأَنَّهُ يُؤَدِّي مَا اسْتَطَاعَهُ مِنَ الْوَاجِبِ. So he needs to do what he can of the obligation. In this case, it's the fidya. And that is a point of agreement amongst the scholars of Islam. You apply this also in transactional law, mu'amalat as well. It's got a very famous example. And from that is, for example, if you agreed with somebody else on a contract that is going to be delayed, for your part of the bargain is going to be delayed in its fulfillment. So let's say somebody bought something of you, that you was going to deliver him this much of this product at a certain point in time. You weren't able to fill its entirety. You're not able to give him everything that he bought off you. Do you just leave off the rest of the agreement? You need to give what you can. Does that make sense? So this is what is referred to as the partial performance of a contract. Ibn al-Qayyim rahimahullah ta'ala says, إِذَا تَعَدَّرَ إِيفَاءُ الْعَقْدِ بِالْكُلِّيَّةِ أَخَذَ بِالْمُيَسَّرِ مِنْ. If he's not able to fulfill the entirety of the contract, he's under the bargain, he needs to take to him what he's capable of fulfilling. So the portion of the contract that he can give, he needs to make sure he does so. And again, look how he uses this principle here. Al-maysur la yasqutu bil-ma'sur. This also occurs in other aspects of aspects of qadha, for example. For example, a good one in qadha is somebody who is going through a court case, right? And he's unable to provide all of the witnesses required for that testimony to be accepted. What does he do? There are witnesses that witnessed an event. Okay? But they don't reach the level that is required. 4, 2, whatever it is. They're not all complete. What does he need to do?
For what?
To forget about for what? Just generally speaking. عموما الشهادات. Present those witnesses. And the fuqaha, even there, they use this qa'ida, which is al-maysur la yasqutu bil-ma'sur. So, for example, you only have one witness to a financial transaction. You bring that one witness, and then what would happen is, after that, they would turn to the individual that is denying, and then he needs to make a yameen, an oath, right? And in nakala, if he refuses to take the oath, then that is your right. The rule will be passed in your favor. So even in that scenario, you don't say, you know what, I don't have the full requirement of what is considered an acceptable testimony in Islam, an acceptable testimony for shahadat. You need to bring what you can. And then the rest of it, you leave to the rest of the process of the judicial process, the qadha process. Ibn Abdul Barr says, إِذَا تَعَذَّرَ إِثْبَاتُ الْحَقِّ بِالشُّرُوطِ الْكَامِلَةِ جاز التيسر بما أمر به الشارع. That if you're incapable of bringing the proof that is required in its entirety while fulfilling all of the conditions, then it's permissible for you to bring that which is easy for you, and then leaving it, the rest of it you leave to the process of how Islam deals with these matters. Are there exceptions to these rules? There are exceptions to these rules. I remember I told you there are أحكام لا تتجزأ. So write down the exceptions to this rule are two. The first is acts that are indivisible, acts that do not divide. Mentioned siyam, mentioned salah as well. We're going to say to somebody, you can't pray 2 rak'at of fajr, pray 1 rak'at. That doesn't make sense. You can't divide prayers in that manner. You either pray the entirety of the prayer or you make it up. Marriage and divorce, these sort of things, all you need to have, this entirety, because it doesn't break apart. You can't have half a divorce, you can't have half a marriage. Things like that don't break apart. So you have to have its entirety. If somebody says, you say to somebody to your wife, for example, I divorce you, or I divorce you with half a divorce, it'd be one. Because you can't break that apart. Does that make sense? So you just have to consider it, one, its entirety. Similarly, what's it called? Ahkam al-Qawāʿid. So qadha, which is the judicial and then the disputed parties, they have a different approach. There is a certain level that is applied, for example, the shuhud and bayinat, but you can't, for example, give somebody half a right in something that does not split into two, right? If somebody, for example, says, I have ownership of something, let's say it's a car, you have to give one person that right. Right? If two people come disputing about a car, you can't both give them. If they both bring evidences, it only have to be one of them that would take it. So qadha is also a slightly different approach to this qa'idah, and so just make it separate as well, even though it kind of enters into the previous one. Shaykh al-Islam Taymiyyah rahimahullah ta'ala says, لا يقبل النصف فيما يتعلق بالحدود والأحكام التعبدية الصريحة. That partial fulfillment is not accepted when it comes to the Islamic legal punishment and acts of worship and things like that. And so these are the two chapters where the people of knowledge, hudud, legal punishments, and al-ahkam al-ta'budiyya and things that are like that. What did we learn from this qa'idah? That what we were commanded with, you have to do them fully. If you can't, you do what you can. Okay? ما تيسر. You do what you can. فاتقوا الله ما استطعتم. This applies to all of abwab al-fiqh. Nothing is excluded. And that there are actions that are excluded from this principle, namely some acts of ibadat and some sort of ahkam qada'iyya like hudud and so on. They're excluded from this. And this qa'idah is an offshoot of al-mashaqqatu tajlibu at-taysir. It goes back to that concept of that ease that can be found in Sharia that we covered yesterday. Is that clear? We'll move on to the next principle now.
أحسن الله إليكم. قال رحمه الله وكل ما نشأ عن المأذون فذاك أمر ليس بالمضمون.
This one, I don't want to spend too much time because we're going to run out of time to go into it. It is slightly similar to a principle we've covered moments ago, but it's slightly different as well. So we do have to, I want to avoid this as much as possible, but we do have to go into a little bit of detail. This qa'idah is known as لا ضمان في المأذون به. لا ضمان في المأذون به. Meaning that there is no liability in that which is permitted. If something is permissible, there is no liability. If you're doing that which you are allowed to do, you're not liable. You're not liable. You don't compensate. Does that make sense? لا ضمان في المأذون به.
There is no liability.
In something that you are permitted to do. If you're allowed to do something, you're not liable. You don't have to compensate for it. And so he says here, وَكُلُّ مَا نَشَأَ عَنِ الْمَأْذُونِ, that every single thing that nasha'a, it stems from, and it comes out of, and it's a result from. It results from al-ma'dhun. Al-ma'dhun is ma udhina fih. So that which you are permitted to do. يعني جاء الإذن, right? مأذون. Anything that you are permitted to do, a permitted act. He says, فَذَاكَ أَمْرٌ لَيْسَ بِالْمَضْمُونِ. Then that is something that you are not held or you're not subject to any liability. Okay? What does this qa'idah resemble?
The one
Which was?
just before 2.
So just say bayt number 31. We covered the من أتلف شيئا.
Yes.
Okay? 31. ومتلف مؤذيه ليس يضمن. It's similar to that in some degree, but it's also different. So we're going to look at the differences between this qa'idah and that qa'idah بإذن الله. متلف مؤذيه was all about the individual that destroyed something, or, harmed somebody in the process of repelling aggression. This one, however, is slightly different. This one talks about anything that you are ma'dhuni fi. So it's more broad in that sense. What are you ma'dhuni fi? Like, what are you permitted to do? The people of knowledge mention a number of things that or ways of something being permissible for you to do. The most obvious one is that which Allah Tabaraka wa Ta'ala allowed you to do. In that context, for example, that individual that defended himself, we see the evidences, right? We see the evidences that it was permissible for him to react in that way. So Allah Azza wa Jalla permitted for him to do that. This is what we refer to as al-idhnu shari. Al-idhnu shari, which is that the Sharia permitted self-defense. The Sharia permitted self-defense.
That was the previous claim, right?
Huh? That was the previous one, but we're going to see other forms of al-idhn al-shar'i as well. Just jot down al-idhn al-shar'i. From amongst idhn al-shar'i was what we covered there, which was the self-defense. So Sharia permits self-defense. We also have what is considered al-idhn al-urfi. Al-idhn al-urfi. Al-idhn al-urfi is where society normalizes certain things and then you act based upon that. So here you've got the Islamic sort of permission. Islam permits for you to do certain things. You've got society permitting certain things because it's a normalized behavior and you act in the way that society would allow you to do. And so you're not going out of bounds. You can also have, for example, al-idhn al-shakhsi. I can tell you, for example, oh, you know what? I'll let you sell my iPad or my phone or this or that. This is me giving permission for you to do that. If I go, Individual permission. If I give you the permission to act in a certain way, and there are any sort of unintended consequences that happen as a result of that. So he says, مَا نَشَأَ عَنِ الْمَأْذُونِ. There are results that I don't like. For example, I told you, go and sell my phone, for example. I didn't tell you about certain price or anything. You tried selling it, but you realized the market is not accepting, a certain price, market price. So you dropped it a little bit. You come back to me with a sum of money. I'm like, I'm not happy with that. Are you liable for having sold it below market rate? I didn't tell you anything, right? And so all of these things go back to this principle of كُلُّ مَا نَشَأَ عَنِ الْمَأْذُونِ. كُلُّ مَا نَشَأَ عَنِ الْمَأْذُونِ. Anything that you are permitted to do. If I told you, look, deal with this in a way that's reasonable and you did that, then you are not liable for any consequences that come as a result of that. Any action that, may be considered problematic, you are not responsible for. So the opposite is also true. If the action itself was not permitted, then anything that happens as a result of that, you are liable for. So I'll give you a good example. If you sold something, belonged to somebody that has nothing, nobody permitted for you to go around and sell it and take it and do anything, nobody gave you a clear-cut permission to do that, then you are liable for that, along with anything else you may have lost in the process. Does that make sense? And so this qa'idah is generic like that. Allah Tabaraka wa Ta'ala says, مَا عَلَى الْمُحْسِنِينَ مِن سَبِيلٍ. That there is no blame upon those who do good. And so the people of knowledge, they take away from this ayah that anybody who does anything rightfully and correctly, ihsan, does it in the best manner possible, then there is no liability upon it. There is no blame upon him. مَا عَلَى الْمُحْسِنِينَ مِنْ سَبِيلٍ. There's nothing upon him. He did what he needed to do. He did the best that he could. He did it to the level of ihsan. And so anything above that, he can't do. So any unintended outcomes, he's not held liable for. Allah Tabarak wa Ta'ala said, وَلَا جُنَاحَ عَلَيْكُمْ فِي مَا أَخْطَأْتُمْ بِهِ وَلَكِنْ مَا تَعَمَّدَتْ قُلُوبُكُمْ. Anything that you do out of mistakes, remember we said earlier, byproduct, then we're not liable for, except that we did intentionally. And this person, it goes back to إسقاط الخطأ. And the mistake that he did, it was by mistake, he didn't intend it. He did the best that he could.
Sheikh, this qaida,
Yeah.
في مأذون به.
Yeah.
Can we say that this is the main principle and the offshoot of it is
yes, they're slightly related. And to be honest, Qawāʿid al-Dhaman, the problem with Dhaman, and this is just, this is me just giving you a bit of insight. Dhaman enters everywhere. So Dhaman in the books of fiqh, you'll find that they just scattered. The scholars of Islam usually don't even make a mother qaida for it. You'll find that sometimes it comes under la dharra wa la dhirar, other times it comes under this. There's always, some sort of mother qaida it comes under, but it's because liability in itself is not a ruling. Liability is an offshoot of something. So it's almost like saying there's a general approach, something went wrong, somebody became liable. Who do we put this liability on? Do you understand? And so it's an offshoot of a lengthier discussion, and as a result of that, generally speaking, it's not placed under, a direct principle. It's usually scattered. Even in the books of Qawāʿid al-Fiqhiyyah, it tends to be quite scattered.
say qaida mustaqilla يعني?
It is to some degree. If you were to go through the works of the thing, subhanAllah, here in Kuwait, you have in Jami'a Islamiyya, I remember, in Magister, when we did Qawāʿid al-Fiqhiyyah with Sheikh Suleiman Ruhaili, he told us about Sheikh, I think his name is Hajri, Hamad al-Hajri, or Hamad al-Hajri. So he did his PhD thesis in Qawāʿid al-Fiqhiyyah al-Muta'alliqa bil-Dhaman. And it's a very thick book. I remember we did like portions of it for masters, but it was a bit. The only reason why I ended up writing it is because, you've got like principles that are scattered everywhere, and so it just gathers them all together in one book. So it's a good book to probably reference and go back to. But the point I'm trying to make is that in essence, it's not the concept of liability is all over the place. It's not a clear-cut sort of concept that attaches to one particular thing. And here you can see that. So, for example, some of the reasons why there is a liability that comes as a result of this is because لا ضرر ولا ضرار. This person, harmed an individual, and so he deserves to be held liable or held accountable. Right? There are times where تصرف, what you call تصرف الفضولي, right? You go and take somebody's wealth and you just go and sell it on the market. Who told you to do that? Who permitted that? So there's all sorts of reasons why you may be held liable. But the point here is, if it stems from a permission, whatever that permission might be, then you are not held liable. Do you want to dive a little bit into the permission, or you don't want to do that? Should we just go straight to the examples?
Permission, we said 3 types, right?
Yes, but do you want to break it down a bit more or no?
You say like...
It's a little bit difficult, but it's nice. It's quite beneficial. Huh? You'd like it. Khalas, let's start with Idhn al-Urfi, okay? Idhn al-Urfi is any time there is a certain thing or a certain norm that exists in society in general, okay, that permits for a certain thing to happen. So, for example, people that do, certain things and they act within that. So even forms of idhn al-fardi is in reality idhn al-urfi. So society is basically, if you, for example, right now, if you gave the right of selling your house to an individual, right, a realtor, whatever it might be, that realtor would behave within the realms of what society allows him to do. Okay? So idhn al-urfi does overlap with this. Which is why some of them even define it as every idhn that is you give to somebody else or society gives to them. And it includes other things as well. Like for example, if for example a yatim, he didn't give the orphan, doesn't give the right of his money being spent on him or whatever to an individual. The Sharia gives that man the permission, but how he uses that money is governed by, again, the urf. Does that make sense? And the people of knowledge, they mentioned two conditions for that. The two conditions are namely أهلية المأذون, which are that the individual that is being given permission is qualified. Qualified to التصرف, to behave in that manner, to do certain things. If he himself is like mahjur, for example, he's known of like spending too much and he's in debt for loads of money, he shouldn't be in charge of an orphan's money, for example. So that's mainly what they mean. The second principle is that the individual, that his right is being taken over in utilizing in this manner, that he has ownership over whatever permission that he's giving. Whatever permission that he is giving.
He has the ownership.
Ownership, yeah. Like, he's got milk. So what you can't have right now is, for example, I don't own a car.
Okay.
I know somebody owns a car. I come to you and I say, can you sell that person's car? And then you act based upon permission of somebody that does not own the property. Does that make sense? Because that just creates another person in the chain of, all people that are behaving outside the scope of what they're allowed to do. So it can't be a chain reaction in that way. Al-Idhn al-Shar'i is Allah Tabaraka wa Ta'ala permitting His slaves to do certain things. And that, generally speaking, occurs in a range of areas, but particularly in places like qadha, right? Passing rulings, that somebody is appointed to pass an Islamic ruling, for example, the Muslim ruler, and all of these different scopes that they behave and they do what they do in the scope of what is considered in the scope of al-maslaha. That is what is more advantageous for the Muslims, the Muslim societies, the Muslim people involved. And so that is the first condition. And the second is intifa' al-dharar. Intifa' al-dharar. Again, the removal of any harm from either the individuals involved or themselves even. I want to go through some practical examples so you can actually see it, inshallah ta'ala. A good example to go through, the last part, is actually a very good example actually is, say somebody commits a crime. Let's say he steals. He's taken to a judge. The judge passes a rule based on what he knows, his knowledge, right? And somebody then goes and cuts off the hand of that individual. This person that cut that hand, what scope did he have to cut that hand? Where did that permission stem from? Shar'i. Allah Tabaraka wa Ta'ala permitted the people who are in charge of that role, وَالسَّارِقُ وَالسَّارِقَةُ فَاقْطَعُوا أَيْدِيَهُمَا. Permitted that, okay? Now, say later on, the evidence becomes clear that there was something wrong with that. Is the person that cut his hand liable for anything?
No.
Why? Because he acted upon the permission of Allah to do so. Does that make sense? So he's not liable for anything. مَا أَخْطَأَ فِي شَيْءٍ. Does that make sense? He acted upon the command of Allah Tabaraka wa Ta'ala, the fact that Allah Azza wa Jal permitted that for him. We've seen moments ago as well, earlier in the day, we've seen the issue of the individual that defends himself, self-defense. The Sharia allowed that for him. مَنْ قُتِلَ دُونَ مَالِهِ فَهُوَ شَهِيدٌ مُقَتِلَ دُونَ نَفْسِهِ فَهُوَ شَهِيدٌ. All those ahadith that show that self-defense is an act of something that Allah Tabaraka wa Ta'ala permitted. One of the things that I want to see is, and this is a very interesting one, because sometimes we do, especially like certain crowds of people, they tend to have a bit of a mistake with this one. Say you sold something to somebody, let's say like a knife or a weapon or something, or even other things. It just can apply to a range of things. But then later on you discovered that that item was misused. It was discovered the item was misused. Are you liable for anything?
No.
Why? Because you simply sold something. Does that make sense? So here the fuqaha would say, من باع سلعة بإذن الشرع فلا ضمان عليه فيما بعد ذلك أو فيما نتج عن ذلك. So if you sold an item and that was permissible Islamically, the Sharia allows you to sell it, then anything that comes from it, you are not liable for.
Does ignorance play a role?
Which one?
Ignorance.
Yes. Ignorance is a big role. So if you know somebody's going to use a weapon to kill somebody, that's a problem. You should be selling weapons. But if you didn't know, you're just selling مثلا, a knife that was going to be used to cut bread, for example, and it was used for something else, you're not liable for that. You're not liable for that. And you can't close the doors of that to society as well. What we're supposed to use for cutlery, right? These things have to be available. Just because some people are misusing it does not mean we can close the door of these things to society in a whole. And so this is important to be aware of, and all of that stems from this principle. Let's avoid certain things. نعم. A doctor. جاء في الحديث, right? من تطبب وهو لا يعلم الطب فهو ضامن. And the opposite of that is the one who is a qualified doctor. So here in the book of fiqh we have a medical treatment that was on. A qualified surgeon performed surgery upon an individual. Let's say he died or whatever, there was an injury that was sustained on him. Is the doctor liable? Why not?
Because he was
specialized in it. He was doing something under the permission of Allah Ta'ala, Ya ibadallah tadawu, right? Seek cure and all these things. This commandment applies. Allah permitted us to do these things. Urf as well, society allows for that. Even if, for example, in today's age, for major surgery and things like that, you tend to sign an agreement, right? The sort of like a risk assessment agreement and things like that. Even if you didn't sign it, the doctor Islamically would not be liable. And so Ibn Abd al-Barr, for example, says, "Man amila fi majalihi bi'idhni shar' fala dhamana alayh illa in ta'adda aw farrat." That whoever does, an act which is within his scope of expertise in his field, then he's not liable for anything that comes from that, except if he transgresses or is negligent. If he does things that are not usually done, right, or he's negligent in doing things that he was supposed to have done, here you can say you're liable. But in essence, he would not be. Let's say, for example, this is an interesting one that comes in some of the books of adab. A teacher hit a student, and the student died. Died. Is the teacher liable for that?
He hits a
student. Yeah.
Where, which part?
For the punishment. As a punishment.
Let's say he hit him.
As a punishment.
Yeah, as a punishment.
قتل خطأ يعني.
قتل خطأ. But let's say, I don't know, hit him on his head.
Yeah,
if he's not permitted, of course, then he's liable.
This is sort of where the urfi part does come in, because sometimes you do get you get that thug, right? You're hit sometimes in a way that sometimes it's not normal, but it does happen.
Depends if the urf allows it or not.
Huh? It depends, yeah. I guess so. Yeah. Allah understand. But in essence, the books of fiqh would say that the teacher isn't liable. Because part of the scope, obviously today is a bit different, we don't really have these sort of laws. He's not liable. Because part of the teacher's role is the ta'deeb of children and things like that, and the tarbiyah. And that sometimes happens with children. That sometimes happens with children.
In UK, it might be liable.
Yeah. It would be more than liable. Allah understand. Allah understand.
Anesthetician.
Huh?
Anesthetician.
Which one?
Anesthetician who gives the
Anesthesia.
Oh, anesthesia, yeah.
he use overdose.
Yes. So that's what you'd call ta'adda. He transgressed. He gave him more than he was supposed to. Right? But if somebody who's expert in his field and he knows this is the amount he's supposed to give, then he gave that much, but because of, اختلاف أجسام الناس, for example, people's body react differently to different things. And so your body reacts differently and you sustain an injury. And even anesthesia, things like that, even if you give a normal dosage, sometimes you do get it causes, what do you call it? Yeah, you get side effects and all such things. SubhanAllah.
So it's not liable.
No, he's not liable. As long as he did, what the scope of his field allowed him, the normal sort of state of, what his field is, then he's not liable for any of that. Yeah.
The Kuwaiti government does not allow.
Children of children, don't hate children. Allah
Don't touch anybody in the body.
Allah understand. So the last thing we'll go through is the exception to this rule, which is what we're just talking about right now. The exception to this rule. Where does this qa'idah not apply? This qa'idah, number one, obviously does not imply if you do not have permission to do this. If you are not a teacher, for example, outside of Kuwait, you should not be hitting children. Do you understand? So if you do not have a right, if you see a child do something wrong in the corridor, for example, what is your relation to him for you to grab him, do something to him? If you're not a doctor, how can you just impose yourself and start, practicing all these scenarios? If this is not something you have a right to do, either by society standards, idl urfi, or by Allah Azza wa Jal permitting it, then you are dhamin, you are liable. Yeah.
If there is idn al-shakhsi,
yeah.
مثلا,
Idn al-shakhsi is an overlap really of idn al-urfi, but quite often it's more specific. It's me giving somebody direct permission to something. Like for example, sell this house for me, sell this for me.
Sometimes let's say if there's a new doctor, maybe he has just started practicing, or maybe internship something, for example.
Yeah.
And the person, he allows him to, treat somebody from his family, like idn al-shakhsi, but it's not.
That sort of scenario would not really be like a personal sort of decision, because at the end of the day, even that's why we have like what you call guilds and unions and things like that, right? Like for example, right now, if you graduate from a medical sort of school, you don't just become a doctor. You have to, pass a board, right, exam. And in most countries, like, I don't know if that applies to all countries, but there are many jobs where you don't just get, your certification and that's it, you just start the job. There's got to be a phase of training, especially when people's lives are involved. So in that scenario, it's not just idn shakhsi. It's more to do with the fact that society as a whole believes in that standard, and as a result of that, he behaves based on what the standards of that profession allows. Teaching is like that. Being a lawyer is like that. All these different jobs that really do affect people's lives, there is a standard that they are held to, and if they maintain those standards, and that's what this qa'idah goes back to. There's al-urfi, we've created a structure for that in this day and age. And it's been in existence for years and years. The guilds have existed for a very long time.
This is the first exception. That if
Yes. So as long as you're doing that in the scope of your field of expertise, or the Allah Ta'ala permitting that for you. So if you're doing this as a result or based on, some sort of permission, whether it's from society, whether it's from the person, whether it's from Allah, right? This, you're not liable in essence.
you said the exceptions, it doesn't apply if you're not permitted to do.
Yes, if you're not permitted to do, if you're doing this from your own volition, you have nothing to do with the job. You came and stepped in and said, I'm going to do this. Something happens from that, you are liable. Does that make sense? So, al-ma'dhoon, the opposite of that is who? غير المأذون. The person does not have idhn. The person that have idhn is always liable. If I take your phone and sell it on the marketplace, and then I sell it under the market price, and I come back to you and say, I've sold your phone. And he's like, who told you to sell it? I need to pay full price. Does that make sense? You had no permission to do that. The next is, and this is if you have permission, is that there is no tafriq or ta'addi. Tafriq is negligence, and ta'addi is transgression. You didn't do things beyond the scope of what you were allowed, nor did you do it beneath what you were allowed. For example, you're a teacher. You need to look after the students. If it turns out that you didn't really care for them appropriately, you were negligent, and some sort of harm befell them, you are liable. Similarly,
how you mentioned about the doctor.
Similar, again, even the doctor, if he didn't practice, the standards of what medical profession means in whatever country, the standards that they have, if he didn't do what the standard was, he is negligent and he is liable. So إذا ثبت التعدي أو التفريط ثبت الضمان. So there we also excuse.
Okay.
Ta'addi is transgression, goes beyond the scope of what his profession allows. And this applies to everything. This applies to everything. As a doctor, the surgical mistakes that he can make. A landlord, right? Rents property, right?
Policeman. Policeman.
Even police, yeah. Even people that work for the government, they can make serious mistakes in these things. The fuqaha, the books of fuqaha, they mention the executioner, right? If the executioner, مثلا, if the Sharia allows you to cut the hand, so he cuts a whole arm. Who permitted that? Allah didn't.
It's transgression.
There's transgression. So you would be liable to something there. So that's harm beyond what the scope of the Sharia allowed, and so you become accountable. Shaykh al-Islam Taymiyyah rahmatullah says, to conclude this qa'ida quite quickly, he says, إِذَا تَعَدَّ الْفَاعِلُ فِيمَا أُذِنَ لَهُ فَإِنَّهُ يَكُونُ ضَامِنًا لِمَا أَفْسَدَ. If the doer of an action transgresses in something he was permitted to do, then he becomes liable to what he corrupted.
Lumina.
The dhamina lima afsad. So he becomes liable to all the damages he caused. So if you were negligent and if you transgressed, you are dhamin. You need to pay compensation or liable or whatever scope of liability that might be, you need to do. In conclusion, if an action is Islamically permitted or permitted by way of social norms and so on, it has unintended byproducts or consequences, then you as a person are not responsible. That's simply what this qa'ida means. This qa'ida applies to, like we said, remember, all sorts of different things. It applies to judicial rulings, financial dealings, it applies even to ahwal al-shakhsiyya, all sorts of things. Zakah, there are huge examples of that as well. Even, ibadat, they mention things. Even in ibadat, they mention things. All these different things, they come under this principle. What's that example for ibadat? Somebody needed to make wudu. Somebody went and bought him a water bottle to make wudu with because he didn't have money. And then he tried to say, look, give me my money back. I said to him, nobody asked you to go and buy water, right? How can you then ask him to pay him for you? You made that, If he went and said, go and buy it for me, that would be a different story. Because he asked for it. He permitted for him to buy it on his behalf. In this scenario, he didn't. You went and bought him wudu for no reason. He doesn't have to pay you. Does that make sense? I won't get to that anyway. But that's a huge example of something they mentioned in ibadat. But the point is, this qa'ida applies into all facets of fiqh. Exceptions exist, like we said. From that is people who behave outside of the scope of what their field allows. Ta'addi, tafriq, negligence, transgression, and things like that. We'll move on to the next principle, inshallah. Bismillah.
وكل حكم دائر مع علته وهي التي قد أوجبت لشرعته.
This qa'ida is a very famous qa'ida, and it applies strongly in many different capacities. It's one of the greatest qawāʿid that stem from the ahkam al-illah, rulings that relate to al-illah, which is the reasoning or the ruling's initial causation. And so the ruling is always connected to the effective cause, and we're going to see what that is, inshallah ta'ala. And it's used both in usul al-fiqh as well as Qawāʿid al-Fiqhiyyah. The qa'ida simply states, وَكُلُّ حُكْمٍ دَائِرٌ مَعِ عِلَّتِهِ, that every single ruling revolves around. Da'irun, yani it revolves. What does dawaran mean? Dawaran means that it cycles with it. The meaning of it is, if it's there, the illah, meaning the effective cause, the ruling is there as well. You move on. If it goes, the effective cause is no longer there, the ruling goes, what happens to the ruling?
It goes.
It goes as well. So the ruling and the effective cause, the illah and the hukm, they always need to be together. So the underlying reason why that hukm was there, it always has to be there as well. And if it doesn't, then it goes. So the principle states, الحكم يدور مع علته وجودا وعدما. الحكم يدور مع علته وجودا وعدما. So a ruling is dependent on its effective cause. When it exists, the ruling exists. When it ceases to exist, the ruling ceases to exist. It goes. Huh? Depending on its effective cause. Its effective cause. This is a much lengthier discussion over what the illah is. It's a discussion of usul fiqh in reality, and we don't really have time to go through it now. But it's very important that we understand the concept of illat al-hukm. So in qiyas we have al-asl, wal-far', wal-illah, wal-hukm. So you've got 4 principles or the 4 pillars of qiyas. This deals with one of those, which is illat al-hukm. Illat al-hukm, which is the effective cause. We're going to see examples of it as we go through it. I'm going to avoid the whole discussion regarding illah because of time restraints. Dawara we understand, which is that it goes round with it. It exists when it's there, it's no longer there when it's not there. So let's see some examples so that you understand. There's also a difference between illah and hikmah. Just bear that in mind. There's a difference between illah and hikmah. We can't go into that right now as well, the difference between them. But just understand that we're talking about illah, not hikmah. And sometimes you can conflate between the two. The illah for shortening a prayer is what? Traveling. When you travel, you can shorten the prayer. When you stop traveling, you have to complete. You can't shorten the prayer anymore. This is simply what this Qawāʿid speaks about. Mubin leaves Kuwait.
It's hukum of.
He travels to Saudi. He shortens the prayer during that travel. Because you are Musafir, you're a traveler. The Musafir is allowed to shorten. What is the illah? What is the hukum?
Illah is that.
The illah is traveling. The hukum is
Qasr.
Qasr, shortening a prayer. You come back to Kuwait.
Illah is gone.
The illah is gone. The illah is no longer a Musafir, he's Muqim now.
Hukum is also gone.
The hukum is also gone. He's no longer allowed to shorten, he has to complete, to tim salatik. That's all it means, is Qa'ida. So you always have to make sure the illah and the hukum always match. One is with the other. If the illah is there, the hukum is there. If the illah goes, the hukum goes. That's all it means. Do you want to take some more examples or no?
You can shorten or?
Yes. In Saudi, when he's traveling, he can shorten. When he comes back to Kuwait, he has to complete his salah. Does that make sense?
Does he have to shorten it or only if there's like...
No, he can. He's allowed to. This is not a must. It's not mandatory, but he's allowed to shorten. يجوز له القصر. He doesn't have to. He doesn't have to. Okay? But I just forget about all those details. I just want you to understand that there's a illah, there's a hukum. The illah was traveling, the hukum was qasr al-salah.
It's clear, I think.
Do you want to continue? Or do you want more examples or no?
We can, because it's understood.
You understand? Or do you want an extra example? One more, okay. What's the illah of khamr?
Intoxicated.
Illah, not the hukum.
Haram.
Intoxication.
Yeah.
So write sukur. Sukur.
Intoxicated.
Muskir. The Prophet ﷺ said, Kullu muskirin haram. Everything that intoxicates is haram. What is intoxication?
doesn't that do things to...
Covers your.
It covers and it blinds basically your ability to think and understand things because of the what's in your system, right? Intoxicates. Drugs do that, alcohol does that, and so on. So khamr, alcohol, it intoxicates, صح? What happens if illat al-iskar disappears from the drink? It becomes nabith, huh? According to the Hanafis, right? It changes to another state. It becomes just a juice where it was khamr, it's shifted to something else now. Are you allowed to drink it?
If it doesn't intoxicate.
If it doesn't intoxicate, you're allowed. So now it's shifted, right? So that change allows for you to drink that drink because it's no longer intoxicant.
Hukum change it.
So the hukum changes. Iskar is there, it intoxicates, haram. Iskar goes, halal. That's all this qa'idah means. Anybody want any more examples or no?
It's enough.
Let's say, let's do one more. The Prophet ﷺ said, لَيْسَ فِيمَا دُونَ خَمْسِ أَوَاقٍ صَدَقَةٍ. The Prophet ﷺ said there's no zakah due on anything less than 5 awaq, jam'u, awqiyah, of silver. Right? Say somebody has the nisab of fiddah. Right? He's reached there. As a year is about to go by, say 1 year left to al-hawl, for that year of zakat to complete. Zakat would be wajib upon him tomorrow. As the zakat will be wajib upon him tomorrow, he spends a little bit of that savings. So that, he loses some of that money and it's beneath the zakat, the nisab again.
This is why he spent.
Huh? Forget about why he spent it, but is he allowed to? Is he still doesn't to pay zakat or no? Why? What was the illah?
He has to complete the 1 year.
The illah in this context is the nisab. The hukum is wujub al-zakah. So you would simply ask on the day, when a whole year passes by, of those savings, today, on this day after, the whole year, 365 days afterwards, do you have the illah, is it there or not? If the illah is there, the hukm is there. If the illah is gone, the hukm is gone. That's all this qa'idah means. Any other examples or no?
You said that he spent because
Forget about the reason why he spent. I was just let's say he just spent the day before. Yeah.
Without thinking. Right?
Any other examples or no?
We can move ahead because we have
One more. Khalas, no problem. No problem.
finish the Qawāʿid.
Let's say somebody has an impurity on his clothing. Okay? Let's say it's akramakumullah, feces. Right? He puts it in the sun. The sun, due to the intense heat of Kuwait, it disappears. Okay? He didn't clean it.
No signs, no traces.
No sign, no traces. Can he pray with that piece of clothing?
yes.
He can pray with it. So, زالت النجاسة ولو من غير غسل. But the illah was what? Why is he allowed to? The illah was najasa. Najasa is gone now. He can pray with it. When it was there, he could not pray with it. That's all it means. So Nawawi rahmatullah said, إذا زالت النجاسة زال حكمها. Even if it's you not physically having gone in, cleaned it. لأن علته لأنها علة التنجيس. Okay? That the ruling stems from النجاسة. You can apply this to Kitab al-Buyu' as well. You've got so many examples. Qadha as well. You've got so many examples as well. This is probably one of the most common principles of fiqh. You should probably take some time out to memorize it. الحكم يدور مع علته وجودا وعدما. We'll just move on to the next قاعدة.
وكل شرط لازم للعاقد في البيع والنكاح والمقاصد إلا شروطا حللت محرما أو عكسه فباطلات فعلما.
So here he speaks about rahimahullah ta'ala وكل شرط, every single condition, لازم, right, is binding upon al-aqid, meaning the person that entered into the contract, the two contracting parties. It would have been binding upon them. Yeah. So that in itself is really what this qa'idah is about. This qa'idah is referred to as qa'idat al-shurut fi al-uqud. Al-shurut fi al-uqud. And we're going to talk about the scope of this qa'idah because it's very important to understand it correctly. He says here, وَكُلُّ شَرْطٍ لَازِمٌ لِلْعَقِدِ. Every single condition that is made between these two parties becomes binding upon the two contracting parties. He says, فِي الْبَيْعِ وَالنِّكَاحِ وَالْمَقَاصِدِ. In bay', which is sales and financial transactions, nikah, marital contracts, as well as other objectives. Any other agreement that is made between you and another party, it becomes mandatory upon you to fulfill. Then he says, إِلَّا شُرُوطًا حَلَّلَتْ مُحَرَّمًا. Except for conditions that make something that is haram halal. Something that was unlawful, it makes it lawful. Okay? Something that was impermissible, it was made permissible by this condition. أو عكسه, or its opposite. What is the opposite of it?
Haram, halal.
Something that was haram was made halal. Okay? حللت محرما أو حرمت حلالا. حرمت حلالا. It made prohibited that which was halal. Then he says فَبَاطِلَاتٌ فَعْلَمًا. They're all batil, all of those conditions, like the Prophet ﷺ said, وَإِن كَانَتْ مِئَةَ شَرْطٍ. 100 conditions, but all of them are against the Sharia, all of them are batil. It's as if they were non-existent. فَعْلَمًا, so know. Know that they're all null and void. Okay? Before we get into this, I want to explain just one thing quickly. The fuqaha of Islam, you see this a lot in the books of fiqh, what you find is they'll say something like shurut al-nikah, and you'll find another chapter after it called ash-shurutu fi nikah, for example. What is the difference between the two?
Shurut al-nikah, it's like
Before the after the
They're all, every condition is before the action. Every condition is before the action. Does that make sense? So everything we're talking about is before the action. What is the difference between these two terms?
Shurut al-nikah is like which is related to the nikah itself. Yani,
How?
in order to
It is related to nikah itself, but how?
the contract when you are
The wali and all those stuff.
Ahsant. So it's what the Sharia made as conditions, okay? So yes, for the nikah. So shurut al-nikah or shurut al-bay' or whatever it is are the conditions or the Islamic conditions of this. These are the evidences of the Quran and the Sunnah made as conditions for this particular contracts, okay? Shurut fil bay' or shurut fil nikah, where you add the extra fee, is a whole different thing. Okay, so there it's when we stipulate conditions. So me and you, for example, in the midst of this discussion, it's not something Allah Azza wa Jal made a condition for it. We add it on. The fuqaha of Islam discuss it in a chapter right after the first one. They'll say ash-shurut fil nikah, ash-shurut fil bay'. Does that make sense? So there, these are extra conditions that me and you make up. Okay, they're nothing to do with the essential conditions that would. That Allah Azza wa Jal made for that particular contract. Do you understand the difference between the two? Always remember that fee means fee mani, something that we made up. Huh? We made up. Okay. Now these conditions are of two types. These conditions are of two types. What conditions? The conditions that we made up and stipulate. The conditions that we want to add on to this principle. Okay. We split them into conditions that are permissible and valid. And as a result of that, they have to be enforced. You have to do them. They are enforceable. And that is why he says here, وَكُلُّ شَرْطٍ لَازِمٌ. Meaning it's mandatory, it becomes binding. You're forced, يعني ملازم, you're forced to do so. Right? And then you have conditions that are impermissible and that are haram, and that are null and void, and these impermissible conditions, you are not allowed to carry them out. You are not allowed to carry them out. So the Qawāʿid speaks about a range of different topics here. It speaks about a range of different topics here, but they all go back to this topic of ash-shurūt fil uqūd. Ash-shurūt fil uqūd. In a nutshell, ash-shurūt fil uqūd, number one, we have to fulfill. Remember those verses, Ya alladhina amanu awfu bil uqūd, and all those other evidences from the Quran. From the hadith of the Prophet ﷺ said, Al-Muslimuna ala shurūtihim, that the Muslims are upon their conditions. Whatever conditions you stipulate, you have to fulfill. Then the Prophet ﷺ said, إِلَّا شَرْطًا حَرَّمَ حَلَالًا أَوْ أَحَلَّ حَرَامًا, except for a condition that made permissible that which was unlawful, or made something that was lawful impermissible. Any condition that does that changes the hukm of Allah, then it's hadar. We need to get rid of it. That is not fine. So all conditions are binding except for conditions that are impermissible. That's what the hadith states. Now I want to go into something just slightly, just before we get to this point. I want to express something quite clearly before we get to this point, inshallah, which is in its application, meaning shurūt fil uqūd, we have two scenarios, okay? And these two scenarios, if you were to bring all of the shurūt together, they will lead to three scenarios. So combination of shurūt itself and shurūt fil uqūd, you get three scenarios. And I'm going to explain how these splits come about. We have contracts that are referred to as contracts where al-aqdu sahih wa shurutu sahiha. Contracts where the contract is valid and all the conditions within that contract was valid. We have contracts where the aqd is sahih, but the shurut were fasida. But these shurut then gain a specific position which is known as shurutul fasida ghayr mufsida. Meaning that the condition in itself it's invalid, but it does not invalidate the contract. Okay, it does not have the ability to completely override the contract itself. The third is what we refer to as the shurut al-fasida al-mufsida lil-aqd. You have conditions that both invalidate, they invalid themselves, they're wrong, and they also invalidate the contract entirely. So that whole contract we have to start off again. I'm just going to go straight into the examples, inshallah ta'ala, and we'll derive lessons from that. Okay?
Can you mention each category and then the example?
Yes, no problem. Let's just all go through all the examples of عقد صحيح مع شروط صحيحة. Okay? Let's go to bay', for example. A buyer purchases a car. Is he allowed to buy a car? The aqd is sahih. He stipulates in the contract, I want that car delivered to my house. Is there anything wrong with that contract? No. So the condition, what do you say? Sahih is valid. The contract is also valid. That is one example. A customer comes and he says, I'm going to buy this furniture. Is he allowed to buy the furniture? Yes. He wants to buy the furniture, but he wants you to assemble it in his house. You put it together. Is he allowed to demand that as well, as a condition? Yes. He is. So the condition was? Sahih. And the contract was? Sahih. Let's move on to the next one. Nikah. Do you want an interesting one or do you want just the boring ones?
Interesting one.
Interesting, yeah. A woman stipulates that her husband does not take a second wife.
I was about to say that.
What do you say about that? Huh?
Not say.
Why not?
It's
You are making something permissible, impermissible.
But is she making something impermissible?
I'm sorry?
She's not making it impermissible. She's not saying it's haram. She's simply saying, I don't want it.
just putting a boundary.
Huh?
She's just putting a boundary.
She's putting a boundary, yeah. Okay, so here the scholars of Islam differ.
Yeah.
And it depends on the outlook. Is she making something that's halal haram for him? Or is she saying simply, I don't want this in my life? It's halal, I don't dispute it, but I just don't want a second one. And the fuqaha differ on that scenario. But I'll give you one where there is no differing regarding, okay, for marital contract.
What's the answer?
Allah understand. Let's not focus on the answer. We'll get back to that inshallah when we do Kitab al-Nikah inshallah. Let's just focus on the next condition. Okay? Yeah, Allah understand. Allah understand. A wife, she makes a condition as she wants to marry her husband. She says, I want to get married to you, but I also want to complete my studies. You have to pay for my uni fees. She's allowed to demand that.
Yes.
So the condition is valid and the contract is valid as well. Okay? Let's look at one from Ijara. Okay? Ijara. An individual rents a house with the condition that any damages that he incurs in the house, he's not going to pay for it. Like, you know, because he's saying it's going to be from normal usage. Any damages is on you. I'm not going to pay for it afterwards. So I'm going to live in the house for a year, 2 years, whatever, but I'm not paying for any damages as long as it's not excessive and on me. Is he allowed to demand that? Yes. He's allowed to demand that. So the condition is valid and also the contract is valid. An employee agrees as long as he receives an annual bonus. Every single year I want extra kada. An extra 1,000 dinars.
Both correct.
Both valid. He's allowed to do both. It's a mutual agreed upon benefit. That's fine. The next scenario that I want to go through is where the condition is invalid, but the contract is still valid. Al-aqd sahih, but yes, shartu fasid. But al-aqd remains sahih, okay? Let's look at a few. Somebody buys something. Say he buys a mobile phone. You buy it from a seller. The seller says, I'll sell it to you for this much. But with the condition that you are not allowed to sell it on. You can buy this phone off me. But once you buy this phone on me, a condition is you cannot sell it to somebody else after you.
So this condition is
This condition is invalid. But the contract is valid. Because that has nothing to do with him anymore.
Yeah.
Once the contract was complete, he is big. Yes, exactly. Because that opposes the essence of the contract. By you buying this phone, what are you buying? Milkiyyah. You're buying ownership of it. For him to say to you, you're not allowed to sell it is transgressing upon the milkiyyah that you have over that product. And so that's not allowed. Somebody buys a farm.
I'm sorry again?
Somebody buys a farm.
Okay.
And the seller of the farm says, you're allowed to use this farm for anything except for farming. Turn into...
Showpiece or what?
Huh?
Is didn't show please. What?
Last time. What is he supposed to do?
Slap.
Allah. No violence. He only spoke Allah's time. Allah's time. Huh? Shart fasid and aqd sahih. So you simply say, you don't look at that. That's nonsense thing. Because again, milkiyah determines that he can use it for whatever he wants, as long as it's isti'malun mubah. He's using it for that which is permissible.
The interesting example that we gave earlier will fall in the same thing, right?
Which one?
The interesting example.
They're different. They will talk about that. Let me just finish these examples and you'll understand how they're different.
Being recorded, Sheikh.
Yeah, Allah understand. No, they're different. One example from nikah that does actually apply is, so here you have a condition of, let's say for example, a woman, she agrees to marry somebody with the condition that they will not have marital relationships. There will be no intimacy. Huh? So there, what do you say? Al-aqdu sahih wa-shartu fasid. Okay? That condition is invalid. Why?
That's the purpose.
That's the whole purpose of marriage. Okay. Let's move on to the next one. I want you to keep this in mind because we're going to draw a general conclusion afterwards. And I'll tell you why the interesting scenario does not enter into this. Okay? But keep this in mind. The next example. Yeah.
It invalidates the contract?
No, it does not invalidate the contract. It invalidates its condition only. The next example is a landlord rents a house to a tenant, yeah? And he says to the tenant, you're not allowed guests. لا يجوز لك الضيافة. I don't want to see any guests in this building of mine. Only you and your family is allowed to live here. Your parents can't here to eat. Your brothers can't visit for, a get together. Rent this house. The only people I want to see is you and your wife and your children in this house. I don't want to see anybody else. Is he allowed to demand that?
No.
Yes.
Why not?
No,
He's not allowed to demand, no.
because the contract is like giving and it's the use of him.
It opposes استعمال عادي. عادة محكمة. That opposes the normal usage. For him, for example, if he was going to rent the house and then sublet it to anybody, like anybody can visit and take money of them to sleep over in the house for a couple of days, if the landlord said, I don't want you to sublet it, that's fine, that makes sense. Not every tenant has to sublet his house, meaning he rents it on to another person for like, do you lot have Airbnb and things like that here?
What is that?
Airbnb.
Extra.
Yes, things like that. If he said, I don't want that, that would be all right. But if he said, your parents can't even visit, your siblings can't come over, that is, again, what's the point of having a house if other people can't even visit the house, right? So that is against normal usage. We live in a society where people need to interact with other people, visit their homes, come in and out, and things like that. This is a very normal thing. And since the lease demands that, you say that the contract is valid, that condition is invalid. Okay?
So what if there's a risk of these people being youngsters and then they're partying with alcohol and what have you?
Yeah, there's ways of like stopping that. But what you can't say is that nobody visits his house. Does that make sense? There's a way of dealing with some of these problems that sometimes house when you rent a property to somebody. There are issues. We've got to be honest. There's a lot of issues that happens when you rent something to somebody. I remember in Medina, there were so many things that could happen. But you can't close the door upon a normal use. You're supposed to mitigate.
The norms, basically.
Yeah, you have to mitigate a problem in a way that's normal, but also still allow al-isti'mal al-'adi. Yes. Yeah. What can we derive from those examples?
Which examples?
Those 4 or 5 examples that we mentioned.
It was sahih,
Yes.
but the condition was not.
What did it all have in common?
The condition was
Faulty condition.
Why were the conditions faulty?
It's preventing something that should not
What
be
is allowed?
It
was
is
allowed here.
Which is allowed.
You're all saying something, but not quite what I want. So to summarize, just jot this down. Is number 1, they oppose muqtada al-aqd, which is what the contract was there for. The objective of that contract.
the objective of the contract.
Yes. Or they oppose a normative usage. Isti'malun adi. So when these two things, or what happens if you oppose the objective of something or a normal use of something, you get this scenario of what? You just simply throw away that condition, but you keep the contract. The next scenario will be very different, because the next scenario we can't do anything with it. We have to throw it all into the bin. They just have to get rid of it in its entirety. So that's what we're going to look at next. The next to what? Is when the aqd is fasid and the shurut are fasid as well. So an invalid contract and conditions that corrupt that contract. Okay? A man sells a house on the condition that the buyer pays with riba. He pays with installments, and on top of that, he pays riba. What do we do with that?
It's invalid contract.
Riba is both muharram, and it invalidates whatever contract it's in. Okay? A couple agree to marry, man and a woman, with the condition that they divorce a month later. What is this referred to as? Mut'ah. Aqd al-mut'ah, nikah. What is the ruling of that? Haram. But what does it do to the contract? Fasid as well. So there's a shart that's fasid and mufsid. So the aqd al-nikah is batil. It's gone. There's no aqd al-nikah there. Okay? I just...
That point is invalid.
What
can't we say that point?
No, we can't, because we're going to talk about that, inshallah. Just for now, keep this in mind. We're going to go through the reason why. Just as we discussed the reason for that. Aqd al-nikah, aqd al-mut'ah is fasid and it's mufsid. We're going to talk about why that is, so we can understand what the principle here is. So just jot that down for now. Okay. A man marries a woman on the condition that he does not provide for her.
That's making something
Invalid. Both invalid.
Huh?
Invalid. Because the...
Do you not hear of this in Kuwait? Or have you never heard of misyar?
That is from the lady side, right? From the woman.
Yeah, but sometimes the men demand it too.
Aqd is valid.
Huh? No, in essence, if this is done before the aqd, then they're both invalid. It doesn't matter how rich the woman is.
What if they want to marry a rich woman so she can take care of them?
Oh, we talk about these wonderful things, inshallah. Let's just focus on understanding the nature of this contract, okay? But here again, if they agree on this before the marriage, this marriage is null and void, okay?
Things are coming from that side.
Allah musta'an. It's a, yes, they can't stipulate that. They can't stipulate that, yeah.
Like how we said
Even
about
the mahar earlier as well, because that's a condition, yes. I want you to understand what's happening here so that we can deduce the general lesson. Can we see similarities that are forming already or no?
Yes.
No, nothing. Slowly, okay. The next one, inshallah. A landlord rents a house to somebody with the condition that the tenants use it to drink alcohol. Huh?
Again, sorry.
Condition is
The condition is that they use that place to drink alcohol. You have a bar and they drink alcohol in it. What's wrong with that? Promotes haram. Okay? Now I want to quite quickly just see and look into this issue here, which is shurut fil aqd and shurut al-aqd, okay? What we learn from this principle of وَكُلُّ شَرْطٍ لَازِمٌ لِلْعَاقِدِ is, number one, that the default position of Islam is that any condition found in any contract is that the condition is valid and the contract is valid, and that Islam enforces that condition, meaning you have to do it. Okay? That condition is, as the author rahimahullah ta'ala says, إِلَّا شُرُوطًا حَلَّلَتْ مُحَرَّمًا أَوْ عَكْسَهُ, that the Sharia of Allah Tabarak wa Ta'ala, it validates all contracts up until those contracts oppose Islam. So right now, this is another sub-principle, which is you as a person that's saying this contract shouldn't be there. You need to provide the evidence to say this opposes this, the Sharia from this perspective. Does that make sense? The next condition, or the next sort of point that we need to understand with this qa'idah is that a condition is maybe invalid, but does not contradict the essence of the contract itself. And so the condition, the contract remains valid, and the condition can be ignored. The condition can be ignored. We see as well that there are conditions that contradict the essence of the aqd nikah as well, but the entire contract is made null and void. Why is it made null and void? It is made null and void because the Sharia explicitly prohibited these things that I mentioned. The Sharia prohibited riba. Remember we said that the asl is أن النهي يقتضي الفساد. We said earlier that every prohibition يقتضي, that it shows that it's fasid. Here riba was promoted by but was prohibited by the Sharia. Any contract that it finds itself in is also rendered null and void by the Sharia. Mut'a was prohibited by the Sharia. Any contract it finds itself is prohibited by the Sharia. Again, how do we determine when the contract is completely null and void and when it's not? We determine it based upon evidence. If it's the statement of Allah and the statement of the Prophet ﷺ that prohibit that thing being in the contract, then it completely renders it null and void. If not, then we say, look, that's a wrong condition, but we'll fix the contract. Does that make sense? And that's how we approach this chapter. Are we clear on that, or anything else? Can we see that in the context of the ijara? The person that was, renting out a property to somebody with the condition that he sells alcohol. Who prohibited the sale of alcohol? Allah. Any contract that he finds himself in, null and void as well. Does that make sense?
Yes.
Did this simplify anything, or?
Yes.
Are we clear with everything in this qa'idah?
Yes.
So contractual stipulations, shurut fil aqd, is what we're speaking about so far. They are generally binding, except if they can contradict the Sharia. Valid shurut have to be enforced, and they, generally speaking, it's there for something that the buyer or the seller or one party of the contract they want. So it has to be thing. And then invalid stipulations, they have to be rejected, and sometimes the whole contract is considered to be completely null and void. Are we clear? We'll move on to the next principle now.
What if the contract is made, but in that contract there is something which is halal, but it is made haram for you? Suppose you're going in a business, in a company, you're working in a company, and in the contract it is said that you're not allowed to wear specific types of clothes. So what happens in that? Is the contract valid?
No, so specific type of clothes is not considered something. So the fact that you have the freedom to wear whatever clothes you want, that's something personal to you. But if the company says we want you to wear the company attire, the clothing that the company, the workers of the company wear, they force it upon you. That's not something that opposes, not the nature of the act. It doesn't oppose, the conditions that Islam sets for, workers' rights, for example. It doesn't oppose any of that. This is something that is normative, companies do. There's no harm in that. So you have to upkeep that. If that's the condition that you sign with this company, that you're going to wear,
Unless it's haram.
Huh?
Unless it's haram.
Unless it's haram, yeah. If you're wearing something that's inappropriate Islamically or something like that. If they're telling you to dress as a woman and things, then that's
For the woman, for
yeah.
example, to remove the hijab.
Yes, that's a separate discussion, yeah. But in essence, just to wear an attire of a company logo and things like that, that's fine, there's nothing wrong with that. We're going to move on to the next principle, inshallah, due to time restraints, but na'am. How much time do you have? We spent way too much time in that qa'idah. Well, about 50 minutes.
40 minutes. Or 40 minutes.
40 minutes, خلاص, بسم الله.
تستعمل القرعة عند المبهم من الحقوق أو لدى التزاحم.
تستعمل القرعة عند المبهم. Does anybody here know what qur'ah is?
Yes.
What is qur'ah?
Lots that you draw.
Lots. Okay. What are lots?
Decide.
وقرعة الله استاذ الله استاذ So qur'a is when you pick out something from, like for example, you have a paper, for example, and you pick one like that. So say for example, right now, there are few people here that have a right to something. Say they're all one, and there's only one jaiz here. We said, for example, a person who passes the Qawāʿid al-Fiqhiyyah exam gets a hadiyah. The person that gets first place. And then a few people competed to get first place. Here we do a lot, for example. Put all their names in it. For example, write on a piece of paper, put it in a bowl, for example. And we pull one of them out, and they get the prize. Okay? That's what a lot is, a qur'a. And it's something that has existed for centuries. And even in the seerah of the Prophet ﷺ, it was used for multiple things. Wives of the Prophet ﷺ. Where else in the seerah does it come? Huh? Traveling, that he used to use lots. Where else? Huh? No, that was usually assigned. Sallallahu yeah. So the one he'd spend the night with, that was usually assigned. Travel. There was multiple hadith that where the Prophet ﷺ uses Qur'an, inshallah. We'll mention some of them if we can. The author, rahimahullah ta'ala, he says that relying on the lot drawing, so pulling out, one of many options, the Qur'an, is to be used in cases of rightful competition or uncertainty. So he said, تُسْتَعْمَلُ الْقُرْعَةُ عِنْدَ الْمُبْهَمِ. What is al-mubham? Mubham is when something is unknown. Something is unknown, and we're gonna look at why that is. Something is unknown. And the second scenario, he says, من المبهم عند أو من الحقوق, from rights. So two people have a right to something or claim they have a right to something. We're completely uncertain. We don't have any proof for that. Okay? We do qur'a. The second scenario is أولد التزاحم. أولد التزاحم, when there's competition. Say two people, they both get first place in a prize competition or anything. Can I get a charger for my iPad? Have you got a thing? عفوا أخي. الله المستعان. Bismillah. Oh, Bismillah. جزاك الله خير. Oh, no. Wait. أولد التزاحم. Tazahum is when you have a competition over something, okay? A competition over something. So two people maybe won first place, but we only have the ability to give one of them the jaiz or one of them the prize, okay? This is referred to as tazahum. So here the author rahimahullah mentions two scenarios where we apply qur'a. The first scenario is to when people are in conflict over something and they're both claiming a right, over disputing, and they're both claiming a right to something. And this thing cannot be maybe split or something like that. So that is referred to as al-ibham fil ahkam. Al-ibham fil ahkam. Now, the word that's used in English is actually quite big. You sometimes find it in like law, and sometimes even, subhanAllah, when you write in some contracts and stuff like that. It's called indemnity or indemnity. I don't know how to pronounce it. It's like a big word, but it's to do with ibham. So it's ambiguous who this belongs to. And you find multiple claimants to that. And the other scenario is tazahum al-huquq. So which is the competition where multiple people have a right. And so qur'a resolve both. Ayat that speak about qur'a. Yeah. So yes, ibham min al-huquq. Okay? Ibham, there's unknown. We're going to mention the scenarios, don't worry about it. Allah Tabarak wa Ta'ala says, فَسَاهَمَ فَكَانَ مِنَ الْمُضْحَضِينَ. And this refers to the story of Yunus alayhi salam, that he was selected through lots to be cast into the sea. Right? So want to empty out the sea, and they pulled out a lot to get rid of the people on there. They threw Yunus alayhi salam out of the ship. فَسَاهَمَ فَكَانَ مِنَ الْمُضْحَضِينَ. That's a qawl min aqwal al-ilm regarding what this sahm was about. Allah Tabarak wa Ta'ala says regarding the story of Maryam alayhi salam, يُلْقُونَ أَقْلَامَهُمْ أيهم يكفل مريم. What does يلقون أقلامهم mean? Casting their pens to decide. Some of the people of knowledge said again, it's that, they threw a lot. They wrote their name on a piece, they wrote multiple people's names on pieces of paper, and one of them would be pulled out to take guardianship of her. And that was the meaning of the ayah. إِذْ يُلْقُونَ أَقْلَامَهُمْ أَيُّهُمْ يَكْفُلُ مَرْيَمْ. So يُلْقُونَ أَقْلَامَهُم is the Qur'a again. So we've seen in the story of Yunus alayhi salam that there's a qawl, sahama. And in regards to the story of Maryam, it was again the Qur'a. The Prophet sallallahu alaihi wasallam used to do Qur'a with regards to his wives, to pick which one of them would travel with him. And he said sallallahu alaihi wasallam, or it came in the sunnah, that they said, the Sahaba said regarding كَانَ إِذَا أَرَادَ سَفَرًا أَقْرَعَ بَيْنَ نِسَائِهِ. Whenever he wanted to travel, he used to do Qur'a amongst his wife, pick a lot, and then فَأَيَّتُهُنَّ خَرَجَ سَهْمُهَا خَرَجَ بِهَا. So whichever one, her lot came out, he would travel with her. And so the Qur'a is a just method that Allah Azza wa Jal validated in His book. And similarly, the Prophet ﷺ used multiple times throughout his life in many different situations. Salawatullahi wa salamuhu alayhi. The scholars of Islam, in reality, they use it for multiple scenarios. I said to you right now, dispute of rights, which is the ibham. That's one scenario. You also have tazahum of huquq, it's the tazahum, which is multiple people having a right to something. For example, competition. It's also used in sometimes qada and idara, which is to pick for. For example, right now, we said, we want this room cleaned up after we leave today. We said, everybody says, I can't do it. Nobody volunteers. So we said, let's do a qur'ah to pick which one comes out, and then he has to do the job. And that's also a way of determining who's going to do it as well. We're going to just quickly go through some examples, inshaAllah ta'ala. Let me just switch this around. So some quick examples, inshallah. Two people claim a piece of unoccupied land, and they say that they got there first, which is to do with the mas'ala of ihya al-mawat in the books of fiqh. Ihya al-mawat is if there's barren land in the middle of Kuwait, there's a desert. This land, whoever gets there first and occupies it, he gets a right to it. Two people got there first. There's no evidence of who got there first. We don't know who has a right to it. We don't know anything about it, despite two people are disputing about empty land where there's no sign or indicator of anything specifically. Okay? What do we say regarding who gets the right of this land? The fuqaha of Islam say you do qur'a. So in this scenario, you do qur'a. So two people are disputing over empty land. None of them lived there before. There's no indication of who has a right to this and who doesn't. We simply do qur'a. So Ibn Qudama rahimahullah ta'ala says, إذا تساوى المتنازعان في حق ولم يكن لأحدهما مزية فإنه يقترع بينهما. So we give the right of this land to whoever his lot comes out. Okay. Some of the fuqaha even suggest that you do that in adhan. Two people are arguing over who should do the adhan today. There's nobody who has a haqq to adhan, unless obviously it's an appointed position and things like that. But two people want the virtue of the adhan, of doing adhan today for Salat al-Isha. None of them are the appointed mu'adhins of the masjid. It's not his job. They're just mutatawwi', they're just there. Who, as they're arguing, a third person comes in, it's like, a'udhu billah, this is a masjid, what are you arguing about? They say, we're arguing over which one wants to do the adhan. If nobody wants to let go because the virtue of adhan, you simply pull out, you write the two pieces of paper on a qur'ah, and that's it. You pick which one, and that person gets to do the adhan. And obviously this again is seeking the virtue of doing adhan, not just some pointless argument over no reason. This is an interesting one. A man says one of his two wives is divorced, but doesn't specify.
Draw a lot.
You draw a lot, which is قول الشافعي. He says, إذا وقع الإبهام في حكم يستدعى الفصل فإن القرعة تستعمل فيه. No, this is to do with another masala, which is نعم. An individual writes in his will, as his dying will, wasiyah, he says that this thing of mine, which cannot be divided, he says, I'm going to give it to one of two people. Tanwir and Mubin. He passes away. He didn't specify which one. Which one gets it?
Draw a lot.
The qada calls them both. They draw a lot and they give it to one of them. Okay? Because it cannot be split. And this is called al-ibham fil wasiyyah. The first one is al-ibham fil talaq. The second one is al-ibham fil wasiyyah.
Can't we just make like one of them takes the ownership of it, this home, and then the other one just pays the compensation effectively?
But what if they don't have the money to do that? Right? Well, that would be a fair judgment as well. But what if they don't have the money to do so? Right? Because sometimes some things that are like these wasiyas, that's very expensive stuff that are left behind. And so all sorts of things can happen. That would also cause a problem. And why should he pay when he didn't want it before? Does that make sense? It was given to him. Why should he even pay for it anyway? So the people of knowledge say for all these scenarios, تستعمل القرعة. A number of people are selected, like I said, for a jaiza, for a prize. Let's say it's a scholarship. 10 people are selected for a scholarship. There's only 5 positions. What do we do? Qur'ah. And all these different things, you'd have to use Qur'ah. Okay? So Shaykh al-Islam Taymiyyah rahmatullah says, إذا لم يكن في الأمر ترجيح في الشرع فإن القرعة من أفضل طرق الفصل. But if there is no method of determining preference by way of the Sharia with regards to this thing, then drawing a lot is the best way to resolve disputes. And like I said, this is because it's based on not just the story of our Prophet ﷺ, multiple aspects, but even other prophets and the messengers of Allah. This is a huge part of their story. So learning about what Qur'an is and how to do Qur'an properly is a very important thing. This qa'idah, quite simply, we just learned that Qur'an is a valid method to resolve a number of things, such as rights in conflicts. You give a one-party priority based on Qur'an if there's no other method to resolve it. Uncertainty in certain rulings. Splitting between public resources as well. There's evidence of that where scholars of Islam speak about it in Siyasa Shar'iyya. That sometimes, Qur'an is given, 2 cities the government can only spend on, one of them in building something new. Sometimes that can be harmful to the other city as well. You just determine that by way of that. Qur'an obviously does not replace ijtihad fi talib al-haqq. You always have to do ijtihad first. But this is talking about the last result. There is nothing else that you can do. The last thing that you do is you do Qur'an. And so Qur'an is really the final method when all other methods are exhausted. Nothing else that you can do. You just simply return back to Qur'an. And the last thing that we see in this issue is that Qur'an is a fair and a just process. And that as Muslims we don't, look down upon it or reject it. It's fair and it's rational. And it ensures impartiality in many ways. And if there's no other way, this is what we have to go back to, and we have to be happy and content with that. Are there any exceptions to this rule? Are there scenarios where you don't apply Qur'an? The people of knowledge mention certain scenarios. Life or death. One person was killed. 2 people were put on the stand. One of them is going to get the death penalty. Somebody's life was taken. We think it's one of 2 people.
Based on?
Qara'in. The 2 people that were there and things like that.
Well, it's not certain. So
Evidence is not proven.
There's no evidence. So say, for example, a person entered a marketplace. Only 2 people were there in the shop. There's no cameras inside. We only see the camera from outside. Huh? You could say ta'zir, but we're talking about like hadd al-qatl. Do we apply hadd al-qatl? We don't. So you cannot kill somebody without certainty. We can't do Qur'an because there's two options here. It can also not be used as a bayyinah, the scholars of Islam say, an evidence or a proof in judicial proceeding. So for example, right now you've got a scenario where, there's one person that maybe has a right to something. Right? And there's 2 people that are involved in this process. We can't say, Qur'an is the proof here. You know, there's a child, مثلا, that is, requires a parent, for example, or this or that. The proof of which one we're going to give them to is based on bayyina. We're not saying that the end result can't be based on Qur'an, but it cannot be a proof. That drawing lots is not to be used as a proof or a replacement of a shahada. A hujjah always has to be a clear-cut evidence, and Qur'an is not one of them. A Qur'an cannot override a personal legal responsibility. So, like for example, right now, you owe two people debt. And if you pay, this is the last portion of money you have before you become bankrupt. Okay? You can't do Qur'an in repaying those debts. Those debts will always be on your neck. You can choose a way. For example, one of them you can say, look, give me some time. You pay this one, for example. Or you split it between the half up until you get some more money and pay them off. But you can't do Qur'an in those scenarios as well. So again, Qur'an cannot override any sort of thing that you are responsible in fulfilling. Imam al-Shatibi rahimahullah ta'ala draws a conclusion to this in Muwafaqat where he says, Al-Qur'atu tusta'malu fil huquq al-mutazahima la fi ma yunafi mabadi al-ajl. That the Sharia of Allah, it puts the lot drawing in competing rights. Right? Where two people both have a right to something, but you can only give it to one. But not in a way that contradicts the principles of justice of Islam. We can't kill somebody based on Qur'an. We cannot give somebody his due right of wealth based on Qur'an. We cannot use a proof based on Qur'an in qada, because that all opposes the essential principles of justice. Does that make sense? So in conclusion again, Qur'an suggests a legitimate method in determining certain issues. We spoke here about resolving uncertain scenarios, ibham, as well as conflicting rights, which was at-tazahum. It was used by the Prophet ﷺ, endorsed by the Prophet ﷺ, and it came in the stories of so many of the prophets and the messengers of Allah. We mentioned the story of Yunus and Maryam. It applies to many facets of the Sharia. Right? You can apply many things. It comes in ibadat, it comes in other aspects of the Sharia, ibadat, mu'amalat, other such things. The only exception is where it would literally, using it would lead to dhulm, would lead to oppression. You cannot use Qur'an to promote oppression.